Can I start? Good morning, all. Welcome to today's class. I'm your facilitator for today's module. My name is Fumi Ohana. As you can see on the slides, today we will be studying business law, registration, and under business law, we'll be looking at registration of business and compliance uh, requirements. Please, I hope everybody's can listen to me. So let's quickly have a rundown of okay, what I expect participants to know after the end of today's class or this particular module. So I expect by the time I'm done with this module, participants should have the basic understanding of the nature of the legal system in Nigeria, to enable participants understand the legal regime and regulatory agencies regulating businesses in Nigeria, and for participants to know the types of business organization and steps in the formation and registration of businesses in Nigeria, understand the basic nature and elements in a commercial contract. So at the end of this model, these are the things I expect participants to know. After the module, there will be a post quiz. So the questions are going to be based on these objectives. So what are the topics we are going to look at for participants to be able to have an understanding of all the objectives highlighted here? First of all, we are going to look at the Nigerian legal system. Then we'll further look at the relevant government agencies regulating business in Nigeria. Then we'll look at the types of business organizations and legal implication of the various types of business organization. Then we'll look at registration of business uh, organizations. Then finally, we'll look at law of contract. So by these are the topics that will address the business compliance and registration of business. So let's quickly start by looking at the Nigerian legal system. When I say the Nigerian legal system, I'm just talking about the totality of uh, consists of the totality of the laws or legal rules or legal machineries which are, are obtained within Nigeria as a sovereign country. So when I talk of legal rules, totality of legal rules, uh, legal rules and legal laws, I'm talking about all the laws that are obtainable within Nigeria, the constitution, the the institutions that are put in place for the purpose of enforcing these laws, they all comprise to form the Nigerian legal system. What are the laws? We know that the constitution being the ground norm, it is the source by which other laws in the land are gotten. We have various laws in this country. We have state laws, we have national laws. So these laws form part of the Nigerian legal system. And we have institutions, we have institutions put in place for the purpose of enforcing these laws. What are the institutions? So you can see we have the executive arm, we have the legislative arm, we have the judiciary, which are the arms of government. And this, especially the executive arm comprises of the president and his executive, as well as the different ministries and parastatals and agencies under the federal government. So all these ministries, agencies, police, uh, immigration, FIRS, CAC, AMCON, all these various agencies form part of the Nigerian legal system. When you go to the judiciary, we have the courts, we have different tribunals, we have different inquiry panel. All these also or if you put the aggregate of everything together, they form the Nigerian legal system. So basically, the Nigerian legal system comprises of all the various laws and institutions that are obtainable within Nigeria as a sovereign country. So let's look at law. I know everybody has a basic knowledge of what law is, but for the concept and uh, for the purpose of this class, and generally, law has no single definition, but for the law profession, we are more interested in the narrow and direct meaning of law as a rule of conduct, tacitly or formally accepted by people as binding and backed up by some mechanism for the sustenance of its binding nature. First of all, law must be there to regulate a conduct. So in our families, in our different communal settings and societies, associations, we have laws to regulate behaviors. But it's not just enough to have these laws. These laws must, one, they must be formally accepted. If you make a law and it is not accepted by the people, you will find people engaging in civil disobedience. They will be disregarding the law because such laws are not formally accepted. And that institution making that law must be backed up by some mechanism. Like we have our government, there's the constitution that enables the government to make law and to enforce such law. So there must be institutions put in place to enforce such laws because such laws cannot exist in a vacuum. Then let's quickly talk for that law to have a binding nature. So let's look at sources of Nigerian laws. These laws they didn't just fall from the sky. Over time, before the coming out of the colonial masters, we know that various communities and settings in Nigeria have their own laws governing the way they carry out their day-to-day activities. So, however, with the coming of the British, they came with their own laws. So, these laws are collectively the common law and doctrine of equity are examples of laws that were brought in by the British. And these laws are collectively referred to as the Receipt English Law, together with the Statutes of General Application. So, this Receipt English Law, the common law and doctrine of equity, were brought in by the British and they form part of our law. So the common law simply means these are laws that were developed by the by the old courts of common law in England based on the customs and traditions of the people of the realm back then in England. So common law is basically laws based on the customs and traditions of people of England back then that was codified into a written law. And how did they come about this common law being codified into a written law and it became applicable in the whole of England? Before I guess after is it before or after? I'm not too sure, but the Norman conquest, the King Henry uh, was sending out itinerant justices. That is, justices that go around for the purpose of administering justice in different settings in England. So this is just a historical background of how the common law came about. So they went about dispensing justice in different communities in England. So if they go to a particular community, and they see a particular custom is good and should be applicable in all the communities in England, though after they've dispensed justice in the various communities, when they go to the crown, that is London, where the seat of the crown, the one discuss, okay, I came across this custom and this custom was good. So I think we should apply it in the whole of England. Next time, if you go to that particular community, use this community's law to address this particular issue if you meet similar issue. So that was how they came about the common law. But eventually, the common law became more concerned with procedures and forms rather than administering justice. Even where you have a good case, if common law says before you start this case, it must be in writing or you must head it this way, you must head it in the common law courts. If you fail to put in the common law court, then the common law will not entertain your matter, even though you have a good case. So eventually, the common law became more concerned about procedures and form. So people were not getting justice. So the people became aggrieved. The litigants were aggrieved. They could not be issued writ because they were not meeting to the forms and procedure. So if common law is not going to administer justice to them, they began petitioning the crown. And if you petition the crown, you are simply saying, okay, oh, I have a case, I have a good case. But the common law court says it will not entertain my matter because the common law provides that I needed to head the writ as common law court, and I went and headed the writ as common law. So you petition the crown will look at it and say, okay, you have a good case. So that was how the doctrine of equity evolved, due to the fact that most litigants were not satisfied with the justice they were getting. So they petitioned the crown. When they petitioned the crown, it was the King's Council that will hear that matter. And the King's Council comprises of the priest, of the chancellor back then, who has a priestly background. So the King's Council will entertain that matter. So doctrine of equity is not fairness in the common sense. Rather, is these are laws developed by the Court of Chancery for the purpose of mitigating the harshness of common law. So you get it when, if common law says you are supposed to head your writ as common law court, and you fail to do that, and they are not willing to entertain your matter, if you petition the crown, the Court of Chancery will be willing to entertain your matter. So that's why common law and doctrine of equity form part of the Nigerian law. You will see we have some laws that were formulated back then in England that are still part of our laws, and we've even adopted them, we've domesticated them. Then doctrines of equity is still applicable in our law. That's why you get to hear some maxims like, he who comes to equity must come with clean hands, he who seeks equity must do equity, equity acts in persona. All these things were gotten from England. Then we have the Nigerian legislation. These are laws that are formulated by either the National Assembly or the State House of Assembly. So these are laws that are formulated based on bills, democracy, and the rest. So these are laws that are, excuse me, can't hear. Maybe you chatting more. So sorry, uh, I wanted to attend to someone's complaint who says he couldn't hear. So we'll attend to you via the platform. So the Nigerian legislation is there. The legislation is there to make laws. So the laws, if passed, they will pass first reading, second reading, committee reading, they will come to third reading before they are finally passed. Before they are finally passed into law and assented to by the president. So they become the law. So that's why we have some laws like recently passed Companies and Allied Matters Act of 2020, the Bank and Financial Institutions Act. These are examples of laws that were passed by the Nigerian legislation, violence against people's rights. So many laws that have been passed by the legislation in Nigeria from where we started practicing democracy to date, despite the interruption by military rule. We have so many laws that can be credited to our national assemblies in this recent democratic dispensation. So let's quickly look at customary law. When we say customary law, basically, just like customary law is just like the common law in England. It's based on the customs. These are body of rules that are administered based on the customs and tradition of the people. So customary law is still applicable in Nigeria. So that's why we have customary courts and area courts for the purpose of administering customs of that particular locality. That's why you find a judge in a particular custom customary court is is knowledgeable with the customs and traditions of the people. So you see, customary law, like in Nigeria, I like to use the Benin customary law as an example because we have a notorious, the Benin law has a notorious customary law. The Benin custom has a notorious customary law of inheritance where the first son inherits the father's property in which he was staying while he was alive. So is the entitlement of the first son to inherit that particular property. So that custom is so notorious in Nigeria that is judicially noticed. So anytime if there is a matter regarding inheritance of property in the Benin custom and there is a first son, automatically they know that that property goes to the first son. It's not in doubt. The case is Idenhen versus Idenhen. That's a notorious case in the Nigerian judicial palace. Because once the Benin comes to Benin custom and you cite that particular case, which has been decided by the Supreme Court and it has become law of the land, that settles the matter. You don't need any further argument to go about settling that particular matter. Then we have what we call judicial precedent and case law. So judicial precedent, if you can see the hierarchy of Nigerian courts, when I come to hierarchy of Nigerian courts, I will explain judicial precedent and case law better. That's when you have a better understanding of what I'm trying to say. But before I do that, if we say judicial precedent, courts in Nigeria have hierarchies. We have hierarchy of courts. It's not just any court you approach and institute your matters. So even though the legislation or the legislative arm of government makes the law, it is the judiciary that interprets what the law is. So it is in the course of that interpretation that the judiciary will end up making laws. For example, let's say a section in a particular act says, section 20 of a particular act says you should put something in the car. So then there is this argument that in what part of the car are you to put that particular thing? Is it in the boot or in the back seat? So when you go for interpretation, when you approach the court to interpret that particular section, and the court says that that particular thing should be inserted in the boot, then if it goes to the Supreme Court and the Supreme Court decides the same, then that section will be interpreted as you should be inserting that thing in the boot and not in the car. So that's how judicial precedent and case law works. So by virtue of that interpretation now, the judiciary are now making law. Then we have what we call international law. These are laws that govern relationship between different countries. We have different treaties, customs, conventions, practices, international practices that eventually are domesticated by countries. For instance, if you go to chapter 4 of our constitution, which has to do with human rights, fundamental human rights, you will see that we just copied the United Nations Declaration on Human Rights and the African Charter on Human Rights. We still use the African Charter on Human Rights in Nigerian courts if you want to bring an application for enforcement on fundamental rights. This is to show you how international law is still influencing our law and it still forms part of our law. Then let's look at the hierarchy of the Nigerian courts. We have the Supreme Court. The Supreme Court is the apex court of the land, the highest court of the land. If the Supreme Court decides a matter, it becomes final. Any other court below the Supreme Court once they have issues that relates to the one that has already been decided by the Supreme Court, once they have a matter and is similar to the one that has been decided by the Supreme Court, then that court is bound by the decision of Supreme Court on that particular matter. The court cannot deviate. It must follow that decision of Supreme Court in deciding that matter. So once Supreme Court decides on a matter, it becomes the law. And other courts below the Supreme Court will have no option but to follow that decision of the Supreme Court. Then we have the Court of Appeal, which is next to the Supreme Court. The Court of Appeal, as the name implies, is it your appeal matters if you are dissatisfied with judgment of courts of coordinate jurisdiction of superior courts, just like the Federal High Court, State High Court, National Industrial Court of Conduct Tribunals, Securities and Exchange Tribunal, Tax Appeal Tribunals, all these tribunals, and if you are dissatisfied with their decisions, you could just appeal to the Supreme Court or Sharia Court of Appeal and the rest. You can just appeal to the Supreme Court. Then we have the Federal High Court. The Federal High Court, by virtue of Section 251, sub 1, paragraph F of the Constitution, it listed out the jurisdiction of the of the Federal High Court. So if you go to your constitution, you get to see what are those matters that the Supreme Court, the Federal High Court has the exclusive jurisdiction to entertain. These are matters relating to companies, federal government agencies, patent, trademark, copyright. All these are matters that are within the exclusive jurisdiction of the Federal High Court to entertain. Then we have the State High Court. The State High Court has criminal and civil jurisdiction has jurisdiction over civil and criminal matters, with the exception of those matters that are within the exclusive jurisdiction of the Federal High Court and the National Industrial Court and other tribunals and Sharia court. So if you have any civil and criminal matters, you can approach the State High Court, or if you're in the FCT, the FCT High Court, which is the equivalent of the State High Court. Then we have the National Industrial Court. National Industrial Courts are established to entertain matters relating to labor matters. When you have any matter that has to do with master-servant relationship, trade unions, trade organization, employment, employer and employee, the appropriate court to approach is the appropriate court to approach is the National Industrial Court. That's the appropriate court. Then we have customary courts. We have the Sharia courts. The Sharia courts are there for persons who are subject to Islamic personal law to submit themselves to the jurisdiction of that court. And matters are decided based on the Quran and the Hadith. So that's how the Sharia courts operate. Then we have the customary courts. As I said earlier, it's just there to entertain matters between people of the same customs, based on the customs and traditions of the people of that particular settings. Then we have the magistrate courts. The magistrate courts are courts of inferior courts of summary jurisdiction, whereby matters they entertain civil and criminal matters too, but they have a limited jurisdiction, be it subject matter jurisdiction, be it monetary jurisdiction. It's not all matters that the magistrate court can entertain, but they can entertain civil and criminal matters. Then we have the area court. The area court performs similar role as the customary court. It's just nomenclature, change of nomenclature. In customary courts in the south, area courts in the north. Even magistrate courts too in the north, they are still referred to as district courts if they're entertaining civil matters. If the judges, but it's still the same judge that entertains both civil and criminal matters. Now let's quickly look at civil law, because I mentioned you can bring civil and criminal law to either state high courts, magistrate courts, and the rest. So when we talk of civil law, we have civil and we have criminal. When we talk of civil, we're just basically saying we're just basically talking about relationship between individuals. You establish relationship with neighbors, you establish relationship with colleagues at work, business relationship. So when that business relationship, or when a colleague of yours is violating your private right, you have certain private rights, like exclusive possession of your property, right to be paid your if you enter into contract for parties to perform their obligation towards each other. So these are civil law. So if a person wrongs you, you can approach a court and institute a civil matter, especially let's say defamation. He lies against you. Defamation can be libel or slander. Libel where it is published, slander when it is said verbally, trespass when it trespass when you are in exclusive possession of a property and somebody is saying it's his property. We have battery and we have passing of. All these are examples of civil wrongs. Then we have the criminal law. The criminal law is basically to ensure that the society functions well, even though you might be committing certain crimes against persons, but because it is written down as crime, it is statutory, it has been prescribed, and conducts perceived as threatening, and that particular conduct is perceived as threatening and harmful to other members of the society, then such laws will be regarded, such act will be regarded as criminal. Example is when you murder somebody, even though you murder the person is a wrong against that person, but you've caused a grief to the society and you've caused grief to his relatives and the rest. So as such, and already it has been prescribed by a particular law that if you commit so murder in the criminal code, in the penal code, culpable homicide, punishable with death, in in the criminal code is code is manslaughter and murder. So these kind of things are punishable and are written. So you've committed criminal law. And what are those system? What are those institutions put in place to address such? We have the judiciary, we have the police, we have the ICPC, we have the Ministry of Justice and Correctional Service. All these are put in place to address all these issues. So let's quickly look at regulatory agencies regulating business in Nigeria. One of the main topics why we had to discuss the Nigerian legal system is for you to have a basic understanding of the legal system, so that as we are moving forward, we get to know, okay, this is why we have this Nigerian legal system put in place. Because all these relevant regulatory agencies we are going to talk about, if they have any grievance with any business organization, they still take them to court to implement or for them to enforce or to carry out some of their functions against those societies. So we look at the Corporate Affairs Commission in details later. We have the Federal Inland Revenue, which we'll look at too in detail. Then we have the Central Bank of Nigeria. The Central Bank of Nigeria, as we know, was established by the 1958 Act. Let's just quickly look at that. And we know it's the apex court of apex bank of the land. It is the bank of bankers, the bank of last resort. It rolls out general policy for the country and regulates how banking is done in Nigeria. So it's the role of the CBN to also ensure the general economic growth of Nigeria. That is why you see CBN carrying out some policies, just like this loan you are engaged in that you want to apply for. It's one of the roles CBN is playing to ensure that the economy is there's money flowing in the economy and the economy is doing well. Now we have the Asset Management Corporation of Nigeria, AMCOM. AMCOM was established by the 2010 Act and amended by the 2019 Act. The purpose of establishing AMCOM is to ensure liquidity flow in the Nigerian financial system. How does AMCOM ensure liquidity flow in the Nigerian financial system? So AMCOM is there to severe and manage toxic and non-performing loans in bank. For instance, now, let's say there's a company named Johnson Nigeria Limited that approached GT Bank, and it approached GT Bank, it borrowed money from GT Bank, and eventually Johnson Nigeria Limited became unable to service the loan. So as a result, it has affected the balance sheet of GT. So what AMCOM will do, AMCOM will approach GT Bank and say, okay, let's look at your balance sheet. They will look at those loans that are toxic or that are non-performing, those loans that people are not repaying. And they will say, okay, they will tell GT, we are going to buy off the loan from you. Let's say Mr. Johnson borrowed 50 million AMCON will pay back that 50 million to GT. And now Mr. Johnson will be indebted to AMCON, not GT. So by so doing now, AMCON is ensuring that there is liquidity flow within the Nigerian system so that other persons too can come and borrow from that bank. So that's the role AMCON is playing. So we have the National Agency for Food and Drug Administration and Control. NAFDAC, we also look at that subsequently in detail. Then we have the Standard Organization of Nigeria, SON. We'll also look at that in detail. Then we have the the Federal Capital Development Authority, which is the FCDA. We have state commissioners for land and local government. So if your business involves using land, you know the appropriate agency to approach if you are in the FCDA to get the necessary approvals, be it building, be it anything. If you are in another state, you intend to go to another state, then you know that you need to approach that state's uh, land agency or any other ministry that is involved in the administration of land. So let's look at the Corporate Affairs Commission. The Corporate Affairs Commission was established by the Companies and Allied Matters Act of 1990. It is the regulatory agency in charge of registration and regulation of business and non-business organization as companies, business name, and incorporated trustee. So it is the responsibility of CAC to register business and non-business organizations. So business organizations, those ones that are established to make profit. Non-business organizations like NGO, churches, mosques, those ones that are not established for profit making, is all the responsibility of the Corporate Affairs Commission to register such and administer. So by virtue of Section 7 sub 1 of CAMA 2020, it sets out the main function of CAC to include regulation. Before it it regulates how companies are formulated to give you the guidelines. Everything you need is with CAC. It supervises the formation of the company and it sees to the incorporation. It is CAC that will incorporate your company and issue you certificate. Once you are issued certificate, don't think you are done with CAC. CAC will go ahead with to management of the company. Once you are filing certain documents like change of address, change of it still has to be with CAC. And once you feel your business is no longer a going concern, you can wind up the company with CAC and it maintains a company registry in all states of the federation. So CAC plays a vital role when it comes to management of registration of companies. That's why for one of the criteria for applying for the loan is that you must have a business name registered with the CAC. So we are going to look at registration with CAC subsequently in detail too. Also, CAC has the power to carry out investigation into affairs of any organization registered with it to see whether that object, whether the organization is deviating from the object from which it is established. And if CAC finds out that that organization is deviating from the object for which it is established, CAC can take over the management of that organization. It can appoint new trustees in the case of incorporated trustees. In the case of companies, it can appoint new directors to take over the management of the company. Then, in the case of business name, it can appoint new proprietors. So that's the role of the CAC. So let's look at the Federal Inland Revenue. The Federal Inland Revenue was established by the Federal Inland Revenue Act of 2007, and it used to be an organ of the Federal Board of Federal Inland Board Revenue. But however, after the 2007 Act, which established the Federal Inland Revenue, it became an autonomous organ separate from the Federal Inland Board Revenue. So what are the functions? What is the role of the Federal Inland Revenue? It is charged with the collection and administration of federal and corporate taxes. And by virtue of Section 2 of the Act establishing the Federal Inland Revenue Act, it also it's the responsibility of the Federal Inland Revenue (FIRS) to control and administer the various tax enactments and laws specified in the first schedule of the act establishing it. We have various tax enactments like this: Personal Income Tax Act, the Companies Income Tax Act, the Stamp Duty Act, we have the we have the Value Added Tax Act. All these are tax enactments that are administered by the Federal Inland Revenue. And by virtue of Section 25 of the Act establishing the FIRS, it also has the responsibility to see to the enforcement and administration of the various tax enactments. Where you fail to 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 pay your VAT, it has the responsibility to take you to court to ensure that that particular uh, enactment is enforced. And there's one thing earlier I listed out some tax enactments that are administered by the FIRS, but there's no time for us to pick each one and discuss. But for the purpose of this model and the kind of business you are going to be engaged in, I think the one we are going to look at is the value added tax. Because the value added tax, once you are providing any service or you are selling any product, you ought to be remitting your value added tax to the federal government. But that is not without saying that you don't need to remit your personal income tax and the company, especially when you have your company income tax. That does not mean you should not remit those ones to FIRS. So the value added tax is a consumption tax that is levied repeatedly on a product or service offered. So it's a consumption tax. For instance, if you go to a supermarket, you buy products, you will see them charging VAT. You see them charging VAT. You go to uh, any services that is provided to you, you see them charging VAT. For instance, if you make a call with MTN now, if you are using an MTN line, you see them. They will give you the amount and the VAT. Because once you are offering any business or you are selling any product, you ought to uh, remit your VAT to the federal government through the FIRS. So any all existing manufacturers, distributors, importers, suppliers of goods and services are to register with their local VAT office. So that is any office, any FIRS office close to you. You can just approach them and register your VAT. So the prospective VAT payer will obtain and complete a VAT form and return it to the nearest local VAT office. A permanent VAT registration number is to be given to each registered payer. So by so doing, you are to be remitting your VAT to the FIRS via your registered number. So every vatable business you ought or product you ought to remit such to the FIRS. So it's not every product or services that are vatable. Once you check the Finance Act of 2019, even though right now we're in the process of having a new Finance Act, which is 2020, which is before the National Assembly. I think they've passed it into law. It's just for the president, I guess so. So you get to see what products or services are vatable. So, for instance, here I have that cultivation of unprocessed agricultural produce are exempted from VAT and enjoy pioneer status. So let's look at NAF, Standard Organization of Nigeria, SON. So the Standard Organization of Nigeria is a sole body that is vested with the responsibility of standardizing and regulating the quality of products, not all products, because some are administered by NAFDAC, quality of products within their inventory in Nigeria. The Sun has an inventory of products which you need to certify with them. If you go to their website, you get to see this list of products that you need to certify with the Standard Organization of Nigeria. So once you are dealing with any product that falls within their inventory, you ought to register with the Standard Organization of Nigeria. If not, there will be problem, because one of their function is to classificate and destroy substandard products. So, and if you don't register with them, it tends to affect the value of your product in the market, because that is their responsibility to ensure that standard products are being distributed in the market. So, if you check the slide at the end of this class, the slide uh, will be shared via the platform. So everybody will have a copy of the slide. So if you check the slide, you get to see some of the functions of the Standard Organization of Nigeria. So the slide will be shared after the class. So let's look at the procedure for registration with Standard Organization of Nigeria. They have two methods of there are procedures in which you can standardize your product with Standard Organization of Nigeria. We have the e-product registration. The e-product registration, the method too is also listed on the slide. And for further information on how you go about it, you could just visit www.son.gov.ng, or you could just Google it, the e-product registration procedure for imported and locally manufactured products. You will get to see step by step, like you visit the portal, you on the homepage, you click e-product registration. For new company, you click on account, you enter your, so it's on the slide, you get to see it on the slide. And you have you can upload the following documents. And if it gives you the specific documents to upload, if it says you upload it in JPEG or PDF format, and it must not be less than 30 kilo, what are those documents you need to upload? Then you have the CSC certificate, picture of the product, power of attorney, if you are an importer, trademark certificate, and the rest. These are things you need to upload. Then the second procedure for registration is the Mandatory Conformity Assessment Program, MANCAP. The Mandatory Conformity Assessment Program is a mandatory product certification scheme put in place by standard organization to ensure that all locally manufactured products in the country conform with the relevant Nigerian industry standards. So if you are manufacturing your product locally in Nigeria, then it is mandatory for you to undergo the mandatory conformity assessment program. This is for some to ensure that your products are conform to the relevant Nigerian industrial standards before such products are presented for sale in the market or exported. The mandatory assessment conformity, the mandatory conformity assessment program certification involves inspection of the product process, sampling and testing of the product against relevant Nigerian industrial standards to confirm compliance through conformity assessment processes. Report of inspection and test results are complied by state offices and forwarded to product certification directorate for evaluation. If the product meets the required requirement of the relevant Nigerian industrial standard, MANCAP certificate and MANCAP logo, which bears a unique number for that product, is issued for product upon payment of applicable administrative charges. So this is the MANCAP is only applicable when you are locally manufacturing your product. So uh, uh, there is another procedure of registration that is done by the Standard Organization of Nigeria. That one is called the that one is for goods shipped to Nigeria. So a conformity assessment program called Standard Organization of Nigeria Conformity Assessment Program, SONCAP, for goods shipped into Nigeria. So you could just Google exports to Nigeria. If you Google exports to Nigeria, you get to see export guide to Nigeria. You get to see the program, the Standard Organization of Nigeria Conformity Assessment Program. It contains inventory of products that you want to ship to Nigeria, that you need to certify with the Standard Organization of Nigeria. Or you could just visit www.cotina.com. It's on the slide. You get to see, it will bring out the list of products if you want to ship into Nigeria, and you must certify with the Standard Organization of Nigeria. So I'm telling you all this because I don't know the kind of business you go into or the kind of business you are into. If you want to go into sale of different products, then you ought to if you those products that are within the inventory of the Standard Organization of Nigeria, then you ought to certify such before you can start distributing such in the market. So let's look at NAFDAC. You know, NAFDAC is established by the NAFDAC Act, and it has the mandate for controlling, maintaining the distribution. You see, first is the distribution, advertising. If you are even advertising a product that is within the category of products administered by NAFDAC, you need to obtain the approval from NAFDAC. Exportation, importation, manufacture, and the registration of the categories of products such as food, drugs, medical devices. When we are talking of drugs in this uh, context, we are talking of medications, medicines, not drugs as in illicit drugs. So all businesses dealing in food and related products are subject to regulation by NAFDAC. As it is unlawful to market any drugs or consumable goods in Nigeria to public without registration with NAFDAC. So if you are dealing with any of the categories of products that are within the purview for NAFDAC to administer, you must register same with NAFDAC. So let's quickly look at what are those categories of products that you need to register with NAFDAC. Remember, SON 2 has the categories of products you need to register with them. NAFDAC 2 has its own category of products you need to register with them. So if you are dealing with food and water, you approach NAFDAC. If you are dealing with drugs and medical devices, you approach NAFDAC. If you are dealing with herbals and cosmetics, you approach NAFDAC. If you are dealing with vaccines and biologics, you approach NAFDAC. If you're dealing with chemicals, approach NAFDAC. If you're dealing with veterinary products and narcotics, you approach NAFDAC. These are contained in the Act establishing NAFDAC. They listed out, these are the categories of products that are registrable by NAFDAC. So for time and for the purpose of this class, we cannot pick each product and start discussing the procedure of registration. Then we are not going to finish this class today, and it's going to take us the whole of, I think, 6 or 3 months discussing, except we'll be having the class every day. So what I just did was just to pick drugs, and just to the drug itself, I just gave a general requirement, because we cannot pick each drug, because though the registration procedure may vary, but if you look at it, the larger sense, the procedure are almost similar. That's why I say though specific documentation vary for different drugs and food, now the general registration procedure is similar, and is broadly is in a two-stage process. And what are the process? Is first, you application for approval to bring in samples. When you are importing that drug, it's not applicable if you are manufacturing it. Then application for full registration. Application for full registration is the one you do whether you are importing or you are manufacturing locally. So for details on how to register with NAFDAC, you can go to their office at 27 and make inquiries, or you could visit their site. And also, subsequently, if I'm done with discussing with the manual form of registration, NAFDAC have also introduced an e-procedure, e-registration method, which they call NAPAMS. So we'll discuss that too subsequently. So what are the key requirements for registering drugs? As I said earlier, drugs in this instance, in this context, it's not illicit drugs. We are talking about medications, medicines for headache, medicine for all kinds of ailment. If you want to be it about and the rest, you want to register with NAFDAC. What are the key requirements? So we are just going to look at the key requirements generally, and subsequently, it's not just manufacture, exportation, importation, even distribution. You want to run a pharmacy. After obtaining all the license and approval from the Pharmacists Council of Nigeria, what are those things you need to obtain from NAFDAC? We will also see what are those things you need to accompany your application with. If you want to register with NAFDAC, we look at. So what are the key requirements? First of all, you need to know that application is on a single product basis, in the sense that you cannot apply for different products. Application has to be on a single product basis. Let's say, for instance, you want to register a medicine for headache, and you want to register a medicine uh, for stomach ache. So what you need to know is that if you want to apply, you cannot apply for the two at the same time. It has to be on a single product basis, separate for the medicine for headache, separate for the medicine for stomach ache. So that's why I have it here. Application is on a single product basis. Then you have a written application stating the name of the manufacturer and the name of the brand. You complete your NAFDAC application form, certificate of incorporation where it is a brand, a company, you attach it, 5 copies of the product dossier. When we are talking of product dossier, for every drug, it has to go through trials to test the efficacy of the drug, the methods, the procedure used in uh, in in manufacturing that drug. So the dossier comprises of all these things. You need to attach them, the various documents, 3 packs of the product samples. Then we have where you are importing. For instance, now, we have a coronavirus vaccine that's manufactured by Pfizer and Biotech. That is for America. For China, we have the is it the Sinovac or something? So let's say you want to import the one from America, and you want to import. So definitely you will need to have a power of attorney. That's why I have here notarized original copy of power of attorney duly executed from the product manufacturer to show NAFDAC that, okay, I've gotten the power of attorney to import that vaccine to Nigeria. So you see, there's a lot of money in the pharmaceutical industry, because anybody that has such license to import vaccine for corona into Nigeria is not small money the person is going to make now. Because I wonder how much the person is going to dispense, is going to sell the vaccines to different health institutions. The pharmaceutical industry is one big industry where money is made, and most of them are billionaires in that industry. So that one is, by the way. Let's say you've gotten license and approval to import such vaccine. So you need to bring a power of attorney, you're authorizing you to import that. So power of attorney is just a document saying that you've authorized someone to do something in your state. So Pfizer is saying that in Nigeria, they are giving you that authority for you to distribute and sell the vaccines for them. So if you want to get approval from NAFDAC, because is if you are importing and you are manufacturing, you are exporting, you need the approval of NAFDAC. So you need to attach that power of attorney. In the absence of power of attorney, there's certificate of manufacture. Certificate of manufacture issued by a competent health or regulatory authority in the country of origin, authenticated by the Nigerian mission in that country. So it has to be authenticated by the Nigerian mission of that country. That is, if you have a certificate of uh, manufacture. So what are the other things you need? Let's say contract of manufacturing agreement properly executed and authorized by a notary public in the country of manufacture, current World Health Organization good manufacturing practice certificate for the manufacturer authenticated by the Nigerian mission. When we say Nigerian mission, we're either talking of the High Commission if you are in a Commonwealth country, or we're talking of the embassy in countries where there are no there are countries that are not members of Commonwealth, and we have our embassy there. We could approach them to notarize that document, be it the contract manufacturing agreement you entered with Pfizer, or a power of attorney authorizing you to distribute the corona vaccine in Nigeria. If you want to go into distribution, you want to run a pharmacy, what are those things you need to accompany your application to NAFDAC for approval? You have the certificate of pharmaceutical products duly issued and authenticated, the current pretendant pharmacist license to practice issued by the Pharmaceutical Council of Nigeria, premises registration license from Pharmacist Council of Nigeria, certificate of registration of brand name with trade registry in the Ministry of Commerce. Let's say you have a company, a pharmaceutical company, or you have a company that is into the distribution of product. You have a trade name, you have a trademark. So that trade name and trademark, you ought to register it with the trademark registry, with the uh, patent, trademark, patent and design registry of the Ministry of Commerce. So you ought to register it so that in applying for approval with NAFDAC, your application can sail through. Letter of invitation from manufacturer to inspect factory abroad, stating full name and location of the plant, then the applicable fee payable if only if documents are confirmed to be satisfactory. So from this we've gotten what are the requirements, the key requirements if you want to register a drug. So let's look at the e-procedure method of registering with NAFDAC. I guess it was in June or July they introduced this method. So they call it the NAFDAC Automated Product Administration and Monitoring System, uh, NAPAMS. So what you do is you go to www.napams.org, you create an account, then you register as a client. Then after you've registered as a client, you sign in with your register. You choose the category of product you want to register. Is it food and drugs, narcotics? There's a way they did this. You just choose it. That means you must have fulfilled all preconditions necessary for registering. If you need to bring in samples for them uh, to look at before registration, you ought to do that. Complete your application form, you fill in those information required, then you make payments, then they process your application and obtain fee. It's not as easy as I'm saying it. It's not like ABCD or it's taking candy from a kit. Sometimes if you can't do these things, you can approach their office, they'll put you through, or there are agents around. Lawyers are always there and willing. They can help you with those registration, or however they will charge for their professional fee. That is where you cannot do it yourself. So we are done with regulatory agencies. We are going to another part of this module, another session of this module, which has to do with uh, uh, registration of businesses. This is the second arm of the lecture, which has to do with registration of businesses. So when we are talking of types of business organization and the legal implication, and we're talking of the legal implication of the various types of business. So what is a business organization? I know you are running a business. What is definitely everything you're doing is a legitimate venture to make profit. So a business organization is a legitimate venture to make profit. Where you are engaged in an illegitimate venture, that cannot be your organization cannot be regarded as a business organization, even though it will be you can cover it up, but if it's discovered, that particular business organization would be proscribed. So, what are those types of business organization? We have the sole proprietorship, we have the partnership, and we have the company. I want you to get this thing to know the kind of business organization you intend to run. Or if you are running one already, if you're a business person and you are running one, for you to know what type of business you are running. Are you running a sole proprietorship? Are you running a partnership? Are you running a company? So you need to know all these things. You need to know what are the legal implications of running this thing. So it's not just for you to wake up one day and say, I want to run a company. What is the implication of running a company? Or it's not for you to just wake up one day and say, I want to run sole proprietorship. What is the implication of running sole proprietorship? Or you wake up one day and say, I want to go into partnership with Mr. Johnson. What are the implications of, and what kind of partnership do you want to enter? So first of all, let's look at sole proprietorship. As the name implies, sole proprietorship. So one person solely involved in the running of day-to-day business. He takes the decisions alone, he takes the profits alone, he does everything he wants to do alone without consulting any other person. He's in charge. If he likes, he spends the profit. If he likes, he closed for the day by 2 without making any sale. That's him. If he dies, the business dies with him. That's one of the implications of running a sole proprietorship. And another implication is that if you are running a sole proprietorship, your liabilities are unlimited. Unlimited in the sense that when you borrow money from any financial institution, if they are to come for their money where you are unable to service the debt, they are they can come for you personally. They can come for their debt personally. That means they can go after your personal belongings, where you have your television, your mattresses, your pods, anything they can lay their hands on, as long as it's yours, they will lay their hands on it to offset their debt. That is why we said, I said here is uh, liabilities are unlimited. The liabilities there are unlimited. You are not limited, unlike in the case of limited partnership and company. In the case of company, your liabilities are limited. If you are a shareholder, is limited to the extent of your investment in that company. So that is why in the case of company, they cannot come after you. And let me tell you something. One thing with sole proprietorship is whether you register it with CAC, you do not acquire legal personality. It does not separate you from the business. You are still liable. Your liability is still unlimited. They can still come after that particular product. They can still come after you personally. So even you register it with, you do not become a separate legal personality. So what are the implications of running partnership? We know partnership is when two or more persons decide to come together to form a business. Mr. Johnson and Mr. John came together, discussed, and say, okay, we want to run a partnership. So the next question is, what kind of partnership do they want to run? Is it a limited partnership or a general partnership? Each one has its implication. So if you are into partnership now, you need to know what kind of partnership you are running. Are you running a general partnership or you are running a limited partnership? Because each one has its implication. Let's start with general partners. Where you're running a partnership and you are a general partner, let's say Mr. Johnson and Mr. John are general partners. They are running their business and they say they want to be general partners. So that means Mr. John and Mr. Johnson have decided that they want to be involved in the day-to-day running of the business. So once they are involved in the day-to-day running of the business, they are regarded as general partners. So let's say Mr. Johnson now says in the name of the business, they will come after their personal belongings, their personal assets for the debt to be offset. That is why general partners are at risk of having their personal belongings seized to offset the debt and liabilities of the partnership business. Because a business made up of two or more partners, each sharing the business's debts, liabilities, and assets. So by so doing, sorry, this should be there shouldn't be an S here. Should be yeah, since it's ends with double S. So that's the implication of being a general partner. You are liable generally for all the liabilities. So Mr. Johnson and Mr. John are liable for all the liabilities. Where they are unable to pay the debt, they will be responsible personally, so they can come after their personal belongings for the debt to be upset. Then you have limited partnership. Okay, Mr. Johnson and Mr. John says, okay, we want to enter into partnership. There is something. Mr. John says, no, yes, I want to be partner. I want to partner you in this business. But Mr. Johnson, I just want to invest. I don't want to be involved in the day-to-day running of the business. I just want to invest. So in that case, Mr. John is a limited partner, and his investment, he's limited. His liabilities are limited to his investment in the business. Unlike sole proprietorship and general partnership, his liabilities are limited. So when you are entering the partnership agreement, you have to create a partnership agreement to the fact that Mr. Johnson and Mr. John are entering into a partnership business on so date and so date, and it is agreed as followed. With the recital, that means the business is into the business of so. Mr. Johnson is have decided to approach Mr. This, and Mr. Johnson has decided that he wants to invest so as a limited partner. So if Mr. John says, okay, I'm just a limited partner, and Mr. Johnson, once the business commence, and Mr. Johnson ends up borrowing money from a financial institution, and he borrows money from a financial institution in the name of the business, and they were unable to service that debt. Mr. John, being a limited partner, his liability is limited to his investment. Is limited to his investment in the business. So he's not his liabilities are not unlimited, unlike Mr. Johnson, who is involved in the day-to-day running of the business. So that's it between general partners and limited partners. These are the legal implications. So, and there's something you need to know about partnership. Partnership is, if you're entering into partnership, for you to be regarded as a partner in that business, you must be involved in the profit sharing. Profits must be shared equally among the partners. If the profit is not shared among the partners, then there's a problem. You are not a partner in that business. So if you are not involved in the sharing of the profit, don't regard yourself as a partner. So from today henceforth, if you are into a partnership, go and evaluate that partnership. Do you partake in the profit sharing? And mostly the profits are shared equally, except parties decide otherwise. So let's look at the company. There's something unique about companies. Companies, they have these unique characteristics. They acquire a legal personality. That's why in law, companies are regarded as artificial persons. In law, we have what we call juristic persons. We have natural persons and artificial persons. So these are persons that in law regards them as persons. So a company, once you register a company, in the eyes of the law, that company is a person, an artificial person. So is anything that you can do as an individual when it comes to business, that company too can do. Because in law, that company is regarded as an artificial person. That's why on the slide I have, from the date of issuance of certificate of incorporation, the company becomes a separate corporate legal personality. It is a separate human being of its own, separate from its shareholders. Even though the company will have shareholders and directors, but they are separate from the company. The shareholders are just there for the fact that they've invested in the company, so they are just there. So the shareholders are there, but they are not the same as the company. So your liability as a shareholder in that company is limited to your investment. Let's say the company is 1 million share capital and you have 4 shareholders, and the share capital is divided into 250,000 ordinary shares of 1 naira each. So your investment in that, your liability is limited to that 250 million share capital. And once you paid up that your shares in the company, you are not no longer indebted to that company. Your liabilities is limited to that investment. So shareholders of the company have limited liabilities, and the debt of the company is not the debt and liabilities of the shareholders. So you see that the debt of the company is not the this thing of the shareholders. So if the company is indebted to any company or bank, any financial institution, the financial institution will come after those properties owned by the company and not individual, except where there is fraud. Then we'll have what we call lifting the veil. Then the court will lift the veil to see who are the persons behind the company that carry out that fraud. So, what are those characteristics of a company? What makes a company an artificial human being? One, it can buy and own properties. It can buy and own properties. It can enter into a contract. You can enter into a contract. Unlike business name and partnership, you can enter into a contract in the name of that company, and it will be the company's contract. All you need to sign is either the company has must have a seal, so the company's seal will be there to end for all contracts to be signed, and then the director will just sign. Then you can sue and be sued. So the company can sue it is in his name. For instance, Mr. Johnson is running Johnson Nigerian Limited. He can sue in Johnson Nigerian Limited, where the business conducted is in the name of Johnson Nigerian Limited. And Johnson Nigerian Limited can be sued, is vice versa. So, and it enjoys perpetual succession. When we say perpetual succession, that means it lives forever. That means you apply for loan and it's registered in the name. It lives forever. I like to use the example of First Bank when it comes to perpetual succession. If you check the logo of First Bank, you will see that you say written since 1894, I guess 1894. So are you telling me the initial shareholders, the directors that began First Bank are still alive? No. What is just that is uh, sh- uh, First Bank, being an artificial person, enjoys perpetual succession. So if directors die, you can change directors. If shareholders die, you can change shareholders. You can allocate shares. Shares too can be inherited. So all these things are there. So by virtue of that characteristic, so that's what companies enjoy. They enjoy this perpetual succession, and you can apply for loan in their registered name. So we have registration of business and non-business organizations. So you are running a sole proprietorship. So you are running a partnership. You want to run a company. You need to register such business. So why register your business? Registration of business organization is done at the Corporate Affairs Commission, whether be it a business name or a company incorporation. A business, whether small or large, will in the long run. The reason why you need to register your business is because in the long run, the benefit from corporate and fiscal product registration, benefit from corporate and fiscal product registration in the sense that if you want to borrow money from financial institutions, if your company is not registered, hardly would financial institutions be magnanimous enough to grant you loan, because they will feel if you want to register in the name of the business, especially when you want to use that particular business to obtain that loan. And if your business is unknown and is not registered with the CAC, any other financial transaction with financial institution will be difficult for you. And if there are incentives distributed by the federal government, if your business is not registered with CAC, hardly will you be able to access same incentives that is being distributed by the federal government. For instance, the survival fund being disbursed by the federal government is an example of incentive that if you are registered and you've paid your tax, you be a beneficiary. So aside that, if you register, you are also captured within the tax net, which is one of your social responsibility to ensure that you pay your taxes. So let's look at small business startup procedure before we look at what are the documents and what are the procedure and documents you need to submit to CAC when you want to register your business name. Let's say you are running a sole proprietorship and you want to register it. with the CAC, what are, as a business name, or you are running a partnership and you want to register it with the CAC, what are those things you need to, what are those documents, what are those things you need to fill to submit to CAC. So basically, small business startup procedure include you finding a suitable business name to support your business idea, identify your a suitable business location, register the business name with CAC, make sure you choose a name that is easy to pronounce, remember, and has a relationship with the type of business. Register with the Federal Inland Revenue as a value-added tax collection point. Register your products with NAFDAC. Register it with some where necessary. So now let's look at registration with CAC. Is the one of the fulcrum of this uh, uh, module for you to know how to register your business yourself. Where you cannot register it yourself, you can use agents. CAC has agents, accredited agents responsible for registration, where you find it difficult to register your business yourself. So, who are these agents that can register your business for you with the CAC? You have the chartered accountant, the chartered secretary, and you have a lawyer. They are issued with accredited cards with the CAC. The CAC will issue them with accredited cards with numbers. But as an individual, as a proprietor of a business name, or as a director of a company, or as a shareholder of a company, you can create your own portal on the CAC website. You can register with the CAC on their portal, on their website. Then you'll be given you see the procedure where you go about creating your portal so that you can carry out your registration yourself. But where you are unable to do that registration yourself, where you find it difficult to conduct to do the registration, there are agents around that can help you with that. They can put you through with the registration. I've called the agents already, chartered accountant, chartered secretary, or a lawyer. Mostly lawyers are most involved in registration with CA. And you need to know that it's just pre-incorporation. There's a responsibility of that is just pre-incorporation that proprietors and uh, directors or anybody trustee of any business or non-business organization can register yourself. So let's say you've gone to the CAC website, you've obtained your portal, you've created a portal for yourself after registering with CAC, and you were able to create a portal, or you've given your registration to be done to you by an agent. An agent has a portal specifically reserved for him for the purpose of such registration. So first thing you need to do is reservation of name. You know you've gotten a suitable name, but you need to know that such names must not be names that are not in use. Such name must not be names that are restricted by CAC. They must not carry phrases like International Chamber of Commerce, National Chamber of Commerce. They should not use the name of a state except where you've obtained a permission. So these are things you need to consider while considering name of the company you want to use. So let's say you've gotten the name, you submit the name for approval. At this stage, you also pay money for submission of name for approval. So once you insert the name, they will give you option of inserting two names so that in case they don't approve one, they will approve the second one. So if they approve either of the name, they will send a notification to you that so name has been approved. To contain in an approval note, which you are to uh, download from your portal. And once you download that approval note, it carries a code, and that code is for you to go ahead with your registration. So once you enter the code, it will redirect you to a page where you begin your registration carrying the name of your company. You enter details like the names of the proprietors, their addresses, any other information that will be contained in the page. You need your information page of your national identity card, your driver's license, voter's card, or international passport for you to register. So after you've filled in all the necessary information, you download the form, you attach your passport. Sorry, you make payment first. After making payment, and let me go back to approval of name. Once the name is approved for you, it is reserved for 60 days until payment. At the expiration of 60 days, if you've not filled the form and if you've not filled the form and make payment, that name that is reserved for you will expire, and any other person can use that name. So after you've completed all the necessary information, you make your payment, you are going to download the form. After you've downloaded the form, then you you attach passport, you sign. Then there is a provision for uploading the forms on CAC website. You upload the forms back, and they will check and see whether there is anything they need to query. If there's nothing they need to query, then they will uh, they will approve the name, and your certificate will be sent to you via a courier company that will call you that you should come and pick up your certificate. So examples of business names are Tayo and Co, Global Ventures Farms, and etc. So let's look at the procedure and documents to be submitted to CC for registration of company. Now is we've looked at business name. What are those things for company? What are those things you need to submit for company? Before we discuss companies, where the procedure and documents to be submitted to CC for registration of company, I want to bring it to your notice that there are different types of companies. We have the private limited company, we have the public limited company, we have the unlimited company, we have the company limited by guarantee. The type of business you want to enter, or the nature or the magnitude of your business, will determine the kind of company you register. By the time you engage a lawyer, you tell him the kind of business you want to register, or the kind of business you are into. He will advise you on the kind of company you need to register, because based on the information you are giving to him, that he will get to know that, okay, based on this information, you have to register a private limited company. But since for the purpose of this loan application, and I'm giving you this advice here for free, is if for this purpose you are to register a private limited company, considering it's a small business, you are expands, it grows. If you want to upgrade it to a public limited company, you cannot do that. You can do that eventually. CAC has already made provisions for that. And there is something you need to know about private limited companies. Private limited companies, the CAMA has made provisions for one director, one shareholder. That is the recent 20 CAMA. So all companies now, one director, one shareholder can be registered. But the problem is, since they are yet to begin the implementation of the new CAMA, so they are still applying the old CAMA that still makes provision for at least two shareholders in the case of all companies, and uh, maximum of 50 shareholders for private limited companies. And the maximum share capital for private limited is 10,000 naira, as contained in the CAMA of 2020. That was the CAMA that has just been repealed, and the 50,000 naira. However, those share capital cap that were given by CAMA were not even applicable before the coming in of the newcomer, because CAC already says is 1 million share capital. That's the minimum you use in registering any company. And when we say 1 million share capital, we are not saying you pay 1 million to CAC. It's just an artificial valuation of your company. We are saying your company is worth 1 million share capital. And that 1 million share capital is divided into some ordinary shares, be it of 5 naira each, be it of 1 naira each. You can decide to share 5,000 to the number of shareholders you choose to have of 1 naira each. So public limited companies are usually quoted as stocks. These are big companies, so, and are highly regulated by the Securities and Exchange Commission. So let's say now you've decided you want to register your private limited company. You've gotten a name. The name must not be a restricted name. It must not be a name that is in use. It must not be a name that is similar to another name. Because if you don't meet those criteria, CAC will hardly approve the name. So normally, if you want to enter a name for reservation, it will bring out names, options that you are not to insert. Because if you eventually insert those options, there's the likelihood of CAC rejecting your disapproving your name, the name you are submitting to them. So you have to put those names in line with their guideline. So let's say you are the director of the company, you are a shareholder in the company, you've registered with CAC, you've created your portal, or you've hired a professional to do the registration for you, an agent. Definitely you charge for his professional fees. So you reserve the name, just like business name is also reserved for 60 days. And at the expiration of 60 days, if you fail to make payment and upload the necessary information, CAC will allocate the name to another person. So if you if after you've the name has been approved, you have to do your registration and make payment within 60 days. So let's say the name has been approved by CAC, an approval note will be sent to you on your portal. You download that approval note, you enter the code, it will direct you to the page where you begin to fill the necessary information, needed for uh, the information needed for the registration. Information like the share capital of the company, how you intend to share the shares among the shareholders. Then you go to directors of the company. Who are the directors of the company? You fill the information on the page, your name, your address, your email address, your phone numbers, age, your means of identification number, in either your international passport or driver's license. Then you complete other things such as your memorandum of association. The memorandum of association contains objects of the company. What are those things that the company are involved or intend to get in? So that is what the memorandum of the company, and it regulates relationship between the companies and outsiders. Then you have the articles of association that you can just adopt. CAC has its own. You can just adopt that, and maybe subsequently if there are changes you can do post incorporation things with the CAC. Then this after you've filled all the necessary information, then you are to down make payment for approval of name. Before approval, you make payment for approval of names, which is a very meager sum. Then your registration fee, the number of share capital will determine how much you pay for your registration fee, and you pay your stamp duties. So after you make your payment, you download the form, you put in place all the necessary signatures of the shareholders and directors. Then you upload your form on the CAC portal. So CAC, after looking at it, if there is no problem, they will approve it and your certificate will be dispensed to you. If there's a problem, they will query it. You have to go and address that problem before you resubmit it again for them to look at. So that's just it about registration of business with the Corporate Affairs Commission. So let me give you a rough an example of fees payable to CAC. This is just an example. It's not what is obtainable right now. As I told you that the share capital will determine how much you pay to CAC. So just for each, if you are using an agent, this one contains how much you pay for the registration and the rest. This is just a sample I'm using because this kind of fees are subject to policy. They could change anytime. So business name search and all this change of address, certificate, true name, and this thing. So we are on to our final topic for today, which is the law of contract. The law of contract is quite vast. Why do you need to know about the law of contract? Because once you register your company, every day your activity in your company, if you are into selling and buying, you are into providing a service, you are going to be engaged in contracts. So you need to have a basic idea of what contract is, because contract is a very big course. uh, while in the university, we did it in 2 semesters. and a textbook alone of law of contract is quite big. To say I will exhaust everything now, I'm lying. I'm just going to give you basics you need to know about contract. So what is contract? A contract is just an enforceable legal obligation agreed upon by parties. Parties have reached a consensus that, okay, I want to be obligated to this person. I'm obligated to you. Once you've discharged your own part of the obligation, I am obligated to discharge my own part of the obligation. So is consensus reached by parties that they will discharge obligation. They've agreed. It's what we call consensus at them between parties. Then what are the elements of a contract? The basic elements of a contract are offer, acceptance, consideration. When we say offer, is when a party is making an offer to another party that he wants to buy a product from him. For instance, Mr. Johnson has a car. He approaches Mr. John that he wants to sell the car to Mr. John. That is Mr. Johnson making an offer to Mr. John. An offer can go the other way. It could be Mr. John making an offer to Mr. Johnson that he wants to buy his car. An offer can be when you go to supermarkets, you see them display their products on the shelf. So that display of product on the shelf is called an invitation to trade. An invitation to trade. But when you pick that product from the shelf and you approach the cashier that you want to buy that product, you are making an offer. Or when they call for invitations to tender, that is government institutions are calling for tenders. That is invitation to trade. You submitting your offer, you making an application, that is an offer to that government agency that you want a contract. So you can see offer can take different forms and shapes. It can take different forms, sorry. So once there is an offer, there must be an acceptance for there to be a further conclusion of the contract. Because an offer alone cannot make a contract. If Mr. Johnson offers to sell his car to me and Mr. Johnson says no, he's not interested, so you don't even have contract. And beside acceptance, there must be consideration. That is a thing of value must exchange hand. The fact that parties have Mr. Johnson has made an offer and Mr. John has agreed does not mean there is contract already. There must be something of value must change hand, and that something of value can be money. There must be a consideration. There must be money. Money must exchange hands. So once there is exchange of money or anything of value that is considered by the parties to be the reason for cementing the contract, then we are set to say we can say that there is a contract. Aside the three basic uh, uh, elements, which are offer, acceptance, and consideration, we also have forms. Contracts can take various forms. It can be written, where parties will sit down and write down the terms of the contract. It can be oral, where it's just agreed orally, and it can be by conduct. Yes, parties can enter into contract by conduct. For instance, people will just enter a taxi without even saying a word. Once the taxi gets to their destination, they know that okay, they've gotten their destination and this is the amount they are to pay. Then we have legality. The contract must be legal. You don't enter into an illegal contract and expect to say you want to go and enforce it in court. It's not possible. A prostitute cannot, because she's not been paid, cannot go and say she wants to uh, and go to court to enforce her contract. Intention to create legal, there must be an intention to create that legal obligation between parties. So these are some of the elements of a contract. So let's have a rundown of what privity of contract is. Privity of contract is basically it means that only parties to a contract can sue and be only parties to a contract can sue and be sued. So if you are not a party to a contract, you cannot sue that person. For instance, the example I use of Mr. Johnson and Mr. John selling a car to Mr. Johnson, if there's something wrong with the contract, Mr. Johnson uh, can is the only person that can sue Mr. John. And it's also Mr. John that can sue Mr. Johnson. Their wives, if they have any, cannot sue on their behalf. So it must be one of the parties suing on behalf of the or it must be the party in the contract that is suing. However, there are exceptions to this general rule. This one of the exceptions is covenants running with land. Covenants running with land is, all these estate developers, they'll develop an estate and they will give you covenants for you to adhere. Don't do this, don't build that, don't raise a fence, don't do this. So these are things that are covenants which you have to adhere to. So let's say, for instance, Mr. Johnson owns a property here in one of the estates in Abuja, and there are covenants that binds him with the estate developer that he's not to develop his fence to be higher than 17 centimeter. So eventually, Mr. Johnson sold the property to Mr. John. And Mr. John, unknown to him that there is such covenant, went ahead and erected a fence of above 17 meters. What in that case, even though the contract was between Mr. John and Mr. Johnson, the estate management can sue Mr. John because it affects them. They are third party, it affects them. So it's an exception to to privity of contract. So what are terms of contract? When we say terms of contract, we're talking of those things that parties have agreed on. Sometimes they can be expressed and sometimes they can be implied. Expressed in the sense that parties are written them down expressly that, okay, the car must be in good working condition, the car must take me from point A to point B, the car must be fuel efficient, if that's one of the terms you agree before you buy the car. So these are express terms written clearly for parties to see. Implied terms are not express, but by virtue of an express term, there are certain terms that can be implied, even though they are not expressly stated. Because let's say he's buying the car, but it's not stated that the car must move from one point A to B. But it is implied that the purpose of Mr. John buying that car is for him to move from point A to point B. Where that car cannot move from point A to point B, definitely there's no contract. So these are express or implied terms. So let's quickly look at what are those elements that are likely to vitiate a contract. You've entered into a contract, quite sure you've met all the conditions, all the elements of contract. But there are certain acts you engage in that are likely to vitiate your contract. One of such is duress. When you force a party to enter into contract, because we know you said there must be agreement, but you use threat to make a party to enter into a contract. A threat not relating to the contract, maybe you threaten violence on the person that if he doesn't enter the contract, you are going to kill his family member. If he doesn't enter into the contract, you are going to uh, cause harm to his business or anything. This is you making a party to enter into a contract under duress, and in such a case, such contract is can be vitiated. And also under undue influence, when you influence a party to enter into contract, because you have an information or you know something that you used to your advantage to influence a party to enter into such a contract, such contracts are also vitiated by virtue of you using your influence to make that party to enter into that contract. So we have misrepresentation when facts before or at the time of entering the contract are misrepresented, where you lie to a party about the state of a product or a car. Let's say Mr. Johnson told me that the car is in perfect condition, the tires are good, it's just 5,000 mileage and the rest. And when he checked the car, he saw that the car is 5 million mileage. That means that car has been overused and it has just been used and overused. It's just that they just repainted the car to make it seem good. So these are facts being misrepresented before the so in such a case such contracts can be vitiated. You can approach the court and say that okay, this person has misrepresented facts for me, so as a result and it's based on the facts misrepresented I entered into this contract, and as such I want this contract either vitiated by the court. Then we have mistake occurs when the subject matter of the contract is no longer in existence, unknown to parties that Mr. Johnson wants to buy a fuel station in Gwagwalada. Unknown to them at the time they were negotiating and even trying to make payment or even made part payment that the filling station has been burned down. So in such a case, the subject matter of the contract is no longer in existence. So as such, there's mistake. And mistake too can also be mutual in the sense that parties did not really understand the nature of the contract. Let's say Mr. Johnson intends to sell his two cars for 100,000, BMW for 50,000, for 40,000, the Mercedes for 60,000. Then Mr. John thought that Mr. Johnson wants to sell his BMW and Mercedes for 60,000. And he went ahead and deposited 60,000 to Mr. Johnson. Then I know Mr. Johnson said, no, what I said was the message is 60,000, the this thing. That's mistake too, mutual mistake, and it has the likelihood of initiating a contract. Then let's look at discharge of contract. How can contracts be discharged? Contracts can be discharged by performance. Where parties have performed their obligations, contracts can be discharged. Where Mr. A has performed his obligation, Mr. B has performed his obligation. For instance, Mr. Johnson made an offer for the car, Mr. John accepted, and he has made payment, and the car is in good condition as agreed. This under such circumstance, the contract has been discharged by performance. Then we have frustration, the example I use of the filling station where the subject matter is no longer in existence, then it is said that that contract is discharged by frustration because the subject matter, which is the reason for having the contract, is no longer in existence. So such contract is discharged by frustration. Then we have fundamental breach, where there is a breach, fundamental breach to the term of the contract. Let's say he's to supply a BMW for Mr. John, and he went ahead and brought a Honda Accord. Mr. John wanted a BMW, and he is supplying a Honda Accord. That's a fundamental breach to the contract. Then we have mutual agreements. Another way by which parties can discharge their contract is by mutual agreement. They will just agree that okay, uh, they will want to discharge each other from the obligations of the contract. So, what are the remedies for breach of contract? The remedies are damages, which damages is monetary compensation. Damages are just monetary compensation for 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 some inconvenience caused to you due to the breach of the contract. So damages can be general, can be specific. It's up to your lawyer who is approaching to court to know the kind of remedy you will go for. Is it general damages or specific damages? Then we have what we call specific performance. Specific performance or part performance is asking the court to make the other party to enforce to perform his own obligation of the contract. That other party, you are telling the court that, see, oh, I've performed my own obligation, and Mr. A is refusing to perform his own obligation. So you are approaching the court and telling the court that, okay, make him perform his own obligation. That is a remedy in equity, which is called specific performance. But mostly when damages are adequate, the court hardly grants specific performance, except in the case of when it has to do with land matters. That is where specific performance is granted. Then we have what we call ratification. Ratification is just the court altering the terms of the contract, even though the court rarely does that. But there are circumstances that will warrant that. Let's say Mr. Johnson is to supply 50 bags of granite to Mr. John, and he ended up supplying 30 bags. And Mr. Jones is adamant that because he supplied him 30, not 50 bags, he's not going to uh, be part of the contract. In such a case, the court might decide to ratify the contract and say, okay, since yes, you wanted a bag of groundnut, I guess, and he has brought bag of groundnut, but it's not up to the number you want. Instead of 50, he's supplying you 30. In this case, why not just pay him for the 30 and collect the 30 bags? So we have another remedy, which is injunction. Injunction is when you ask the court to restrain a person from doing something. An injunction can be perpetual, interim, interlocutory. It's for the lawyer to know it's not your responsibility. If it happens that there's a time you go to court and you are requesting for any of these remedies, injunction. But in business, you cannot rule out going to court. Sometimes it might just arise. You just have to go to court. So injunction is one of the remedy. Sometimes, depending on the circumstances of the case, injunction can be you mandating a party to do something. Then we have what is called quantum merit, where you've performed your obligation to a certain level. Quantum merit, when you've performed your obligation to a certain level, you are entitled to payment for the level of performance you've offered, as long as it is not your own fault that the person says you should leave. For instance, you are building a house for somebody and you've reached a certain level, and the person will say he doesn't want you anymore to work for him on the project. You could approach the court, and the person is proving stubborn to pay you your balance. You could approach the court and say, okay, please, I want so person to pay me my money. I've performed to a certain level. This is how far I've gone with his building. You can approach the court, and the court will say you are entitled to a reasonable value of service you've offered to that person. As long as it's not his fault, your fault, is entitled to pay you certain amount. Then we have rescission, when the courts rescind the contract totally, especially when there's a fundamental breach. In such a case, the court will rescind the contract totally. So these are just basically the what this module is all about. And we've come to the end of today's class. So if you have any question, contribution, now is the time to ask your question. Just I know you are just two here, so if you have Mr. Christopher and Mr. Godwin, if you have any question and you want to ask, you can. Okay, you are three now. If you have any question you want to ask pertaining to this module, or anything you don't understand, or you want to contribute, you want to make contribution, now is the time for you. You unmute your mic and ask your question. Unmute your mic and ask
Yeah,
your.
Johanna,
Yeah, yes,
thank you
sir.
very much for the lecture.
You're welcome.
The last one, this quantum of merit, quantum merit, I mean to say.
Yes, sir.
Please, can you take that once again?
I said when you've offered service to someone, let's
Yeah,
say for instance you are building a house for somebody. I've constructed the house to a certain level. Then
yeah.
suddenly the owner of the house will tell you, he doesn't want you to continue with the project, and he doesn't want to pay you for how
What you have
far
done.
what you've done. So you can approach the court and say, okay, with your evidence, now this is what I've done so far. And for what I have done so far, I'm entitled to certain amount of money to be paid. So it's a remedy you're approaching the court for. So that is just so it's just a reasonable value of service that we offered for the person. You are telling the court to grant you. You are entitled to payment for such. That's just quantum merit.
All right. Thank you very much.
You're welcome, sir. Any other question?
Yes. Yeah. Thanks for today's lecture. Is Mr. Godwin speaking?
Sir.
Yeah. Thank you. In line with that, there's a situation I have personally that I want to also clarify, because these explanations kind of exemplifies the kind of situation I found myself in. I rendered services to somebody, and all of a sudden the person said he doesn't want to continue with the contract again, and the next thing, he wants to continue with a new set of people without settling the old set of people. What kind of remedies can we apply to ensure that kind of thing is done? Is it not proper that the old set of people should be settled before any work should commence on that or continue on that particular project?
Well, this question you're asking me, this is legal consultation. This should be, you should approach a lawyer. But for the fact that we are here and we are just two, I'll oblige you that privilege of answering a question. Let me know the nature of the contract. You spent money. I guess you've spent money. You've invested money and energy in doing the work. Is that not
Yes.
so?
Yes.
You have evidence of all your payments and everything, and
Yes.
it's not like they are going to start the work again.
No. No.
No. So you can approach the court with your evidence. You have evidence of your payment and everything. Go and engage a lawyer. Tell him of the facts of the matter, how it began. That because these are the things they will plead in court for breach of contract. You can go for damages. You'll be entitled for damages because he has caused you inconvenience. You've spent money, and as well as you can ask for the money you've spent so far, which is the quantum merit for the services you offered for him so far. So this, if you have a good case, you have the evidence, because you cannot just go to court based on facts. You must have evidence that you tender before the court that yes, these are the things you've done, and he has been refusing. I believe you've been sending correspondence and the rest. You've been exchanging correspondence between you
Yes.
and the
Yes.
person. So these are
Yes.
things that will make up your case for you. So you once you approach, you engage a lawyer. I guess the first thing they will do is they will write a demand letter to him, demanding that he pays you for the services you offered. If not, you are going to court and the rest. So once you engage your lawyer, he will expatiate more for you on that. And once you bring out the documents, then you get to see what are the evidence, and you must be ready to spend if you are going to court too. So
Okay. Okay. Thank you very much.
you're welcome, sir.
All right. Thank you.
So, in the absence of, since you're the only one, we've come to the end of this class. There's a second class that will be coming up uh, right now. So, yeah, I'll be exiting, and the other person will come and take over. So, thank you very much, everyone, for
All right.
today's lecture. Thank you, sir.
All right. Thank you very much.
You're welcome, sir.